Mr. Lippert, I think we're ready to go on matter number 13.
Yes, Your Honor, 13, State of Washington, the Chung Dong, Ms. Stone, and Mr. Gray.
Matter number 13, State of Washington.
Your Honor, I'm here to assist the court with this matter. When I answer the bar with full regulation of my rights.
This is your case. You can come forward if you like.
Your Honor, it's a preliminary matter. May I approach briefly on it? I have a notice of media coverage, and I'm not sure of your policy here. If you allow multiple cameras, if you have one video, one still.
Who are you?
I'm Christopher King.
I received your advance notice. I'm going to have that filed. Does anyone have an objection to Mr. King filming today? Hearing no objection, based upon your notice you previously provided, I will permit your recording. I see Mr. Green here as well. I'm assuming, are you filming today, Mr. Green?
Yes, Your Honor, I am.
Okay, and just for the record, can you state who you are?
I'm Brian Green. I'm with the Liberties Champion channel.
Okay. Any objection to Brian Green of Liberties Champion filming here today? None. We'll permit you to film as well.
Thank you, Your Honor.
Mr. King, by the way, you are correct in requesting clarification regarding pooling. At this point, under the circumstances, I'm not going to require pooling.
Okay.
Okay, but going forward, any further requests in this matter or any others, that is an issue that should be raised with the court.
Absolutely.
This comes before the court on whatever
I'm answering the bar with full regulation of my rights.
Liberties Champion and Brian Green, who have moved to intervene in this case. The court received a brief from Mr. Joseph Thomas. You are Mr. Thomas.
Yes, Your Honor.
Good morning.
Good morning.
We'll have, if you can slide there if you could. I see Mr. Gray is here as well as Mr. Bang's counsel. Ms. Stone, good morning to you.
Good morning.
So again, the court has received the pleadings from Liberties Champion and Brian Green through a motion from Mr. Thomas to intervene in this case. Before we get started, I guess I noted some information within the pleadings that led me to believe there might be a misunderstanding of some of the things the court has done and things the court hasn't done. So before I hear from you, Mr. Thomas, and I will hear from you, I want to clarify the record a little bit. The court has, of course, General 16 that it follows, which specifically commits the media to film and record court proceedings. There's a physical limitation. The court, of course, also has Local Rule 80, which prohibits recording of court proceedings. And so that the court must ensure both media access as well as prohibiting private recording. Now, within that, let me explain what the court hasn't done in this case. The court has not questioned the character of Liberties Champion as a member of the social media, nor Mr. Green's role with Liberties Champion. Mr. Green has repeatedly been permitted to record in this building, and while not ever making, to my knowledge, a request to this judicial officer, has been permitted in the past by other judicial officers to film. Absent some further information of issues regarding compliance with General 16, I would not anticipate denying Mr. Green the right to film as I am permitted here today. The court's requirement for the provision of media credentials in this case was never broadly imposed on Liberties Champion or Mr. Green. It was specific to Mr. Ritzman only. I see Mr. Ritzman here. The court's requirement specific to Mr. Ritzman was a result of objections raised from the state, coupled with Mr. Ritzman's answers, somewhat ambiguous answers to the court's questions to him regarding his connection to Liberties Champion. I recall asking Mr. Ritzman whether he worked for Liberties Champion, and he said no, that he sometimes provided film for Mr. Green at times. And Mr. Green would decide whether to use them or not. I then, and what I would characterize as a leading question, asked him if he was a contractor for Mr. Green. And he rejected that label as well, saying no, he just films and sometimes gives it to Mr. Green. The media credentials were required of Mr. Ritzman to formally establish, or at least more formally establish, his connections with Liberty's champion. Not a challenge to Liberty's champion, nor to Mr. Green. And if not Mr. Riskman's connections to Liberty's champion, at least his independent standing as a member of the media. Again, in an attempt to balance the permissiveness of General Rule 16 with the course obligation following Local Rule 80. Now, in a handful of instances that this court can recall in the past, when it has requested media credentials of members of the social media, those members, to my knowledge, have always been to provide something. It takes different forms, which is why the court doesn't dictate a particular form, but it has always received something. I hope that clarifies what I perceive to be a misunderstanding of what this court has done. Maybe it does, maybe it doesn't. Now, with that, the issue before the court today is Thomas's motion to intervene in this case on behalf of Liberty's champion, Brian Green. I'd like to give you an opportunity to speak. I want you to specifically address, I did read your brief, I want you to specifically address the authority of such a party to intervene in a criminal case. And how many minutes do you need, Mr. Thomas?
Less than 10.
Okay.
This is a complex constitutional argument.
Well, you may speak. Go ahead.
First of all, I'm not familiar with the plain language in Rule 80 that prohibits prior recording. Can this court please clarify its interpretation of Rule 80 that prohibits private recording? Because the court said it was relying upon that in conjunction with GR 16. And I'm not familiar with anywhere in CR 80 that prohibits private recording. Is this court going to respond, or does it just want me to respond? Okay, I'll just talk then. My understanding is that Court Rule 80 only talks about the procedure of the court recording, not about private individuals recording. If that were the case, then it should fit under GR 16, because that talks about the general rule of everybody recording, specifically the media. And so my understanding, and I would take issue with this court's interpretation of the plain language of Court Rule 80, if it is stating that it prohibits private recording, because I believe it does not under the plain language. To get to this court's question, to address the authority of a party to intervene, this court's ruling that Liberty's champion needed to provide media credentials on behalf of Mr. Ritzman was a part of this case. And so the only way in order to address that was to intervene in this case. It doesn't make any sense to start a new lawsuit. When a ruling was made in front of this case, this court even admitted today in open court that it made a ruling about media credentials. And so it only makes sense in order to address that in front of this court in this case, because that is the context that that ruling was made in front of. And so just from a pure logical standpoint, it makes sense in order to address it. If this court wants me to brief it further, I can provide further legal authority. I believe Seattle versus, or the Ishikawa case, which is briefed in my case, I believe that was a motion to intervene before it went up to the Washington State Supreme Court, but I'd be happy to provide a table of authorities in order to substantiate that point if that's what this court wants. I don't think that a table of authorities is even necessary, because media credentials is an unconstitutional requirement, as I laid forth in my brief. If this court looks to if this court looks at page 8 of my memorandum and points of authority, federal courts have repeatedly held that for the purposes of the media, there's really no difference between the public and the media in general. And for this court to say that it wants media credentials, basically it's just asking for Mr. Green or whoever to come up with a self-identifying piece of paper that is basically meaningless, because anybody can write what they want on that paper in order to satisfy the court's media credentials. So either the individual is going to make the arbitrary and capricious determination about media credentials, or this court is going to make an arbitrary and capricious determination about media credentials, because there is no policy about media credentials written down anywhere. And no matter if the individual makes it or the court makes it, it's going to be arbitrary and capricious. And that's why federal courts have said that there's no real distinction anymore between the media and the public when it comes to open court and when it comes to recording in open court. I've cited several of them inside my brief. First of all, the Citizens United versus the Federal Election Commission from the United States Supreme Court said, with the advent of the internet and the decline of the print and broadcast media, the line between media and others who wish to comment on political and social issues becomes far less blurred. Obsidian Finance Group, LLC versus Cox, which is a Ninth Circuit Court of Appeals case from 2014, says, the protections of the First Amendment do not turn on whether the defendant was a trained journalist, formerly affiliated with the traditional news entities, and engaged in conflict of interest disclosure that went beyond just assembling other writing or try to get both sides of the story. That means that anybody can be a journalist in the Ninth Circuit's Court of Appeals view. This was about a blogger. The Cox case was about a blogger who wrote really negative things about Obsidian Finance Group, and they found the First Amendment protections of the media applied to her as a blogger. So, and as further case in my memorandum points out that there's no distinction in federal courts anymore when it comes to the definition of media and the public for the First Amendment purposes, and so media credentials do not mean anything and are unconstitutional in the sense of the First Amendment. You can even look at Snyder versus Phelps, which is a Fourth Circuit case out of Fourth Circuit Court of Appeals case from 2009 that says, quote, any effort to justify a media, non-media distinction rests on unstable grounds given the difficulty of defining with the precision of who belongs to the media. Flem versus the American Association of University Women, which is a Second Circuit case out of 2000, says, quote, a distinction drawn according to whether the defendant is a member of the media or not is untenable. These cases repeatedly say that the court cannot define who the media is because there's no real clear line. And this court is trying to draw a line by saying that people need to provide, that media need to provide some sort of media credentials. It's untenable, Your Honor. And so it doesn't need to go any farther than today if this court just rules that as long as people ask for permission, whether they're a mother off the street or whether it's the Seattle Times, as long as they come in and ask for permission and they're not making a scene, they're not affecting the administration of justice in this court, that they should be allowed to videotape under the First Amendment of the United States Constitution.
Thank you. Ms. Stone?
As a baseline, I don't even think it's appropriate for the court to substantively address this motion. So when we're talking about it, there's no standing for Mr. Thomas to come into a criminal case with a civil motion. He says it doesn't make any sense logically to file a civil motion, but that's in fact what our court rules require. Criminal Rule 24 addresses intervention in a criminal case. It's
Objection, Your Honor. This wasn't briefed, and she didn't respond to the brief. She had a chance in order to argue this in front of the court. This is an ambush.
Mr. Thomas, please.
So Criminal Rule 24, intervention of right, when a statute confers an unconditional right to intervene, there's no statute implicated here that he has addressed. Number two, when the applicant claims an interest relating to the property or transaction, which is the subject of the action. Again, no property or transaction at issue here for criminal rule intervention, Criminal Rule 24. No such intervention right exists here. If he wants to raise this issue and brief it, it should be handled on a civil motion in a civil matter, not in the middle of a criminal case for which he has no right of intervention. I'm asking the court not even to substantively address the underlying motion and make counsel go through the proper channels. It's not appropriate for it to be addressed under a criminal rule, criminal case. It's a civil motion. It should be addressed under a civil case, period.
Mr. Gray, would you like to speak?
Your Honor, I think there's a lot of interesting issues there. I think that obviously the court has many rules that it needs to put forth to control the courtroom. Personally, I don't care if they film either way, but it makes sense that there's some standard that needs to be involved in terms of bringing in technology. But you know, I have no objection, or as far as representing Mr. Dang, obviously he wouldn't have any objection. So.
Mr. Thomas, final thoughts?
Yeah, this court should disregard everything Deputy Prosecuting Attorney Stone said. First of all, she misled this court on the GR-16 standard. Ms. Stone didn't ask this court to perform an Ishikawa hearing, which is a constitutional standard. Ms. Stone didn't respond to my motion, and then she makes up this argument in court and completely ambushes me. If she would have had the decency in order to even respond to my motion, I could have had this issue briefed and prepped for this court properly in order to argue this today, but I don't, because she didn't even have the common courtesy to even respond and then ambushes me in court today. This is the proper procedure, and I told this court that if it wanted briefing on it, I'd be happy to brief it, because there is very clear standards on this for motions to intervene. And since this happened inside the court, there are property issues involved, there are free speech issues involved. Mr. Green's YouTube channel is a property interest and that he has. I mean, he is the proprietor of Liberty's Champion. I don't see Ms. Stone addressing that. He has constitutional interests, and Washington courts have held constitutional interests act as statutes, especially in the Public Records Act spectrum. They act as other statutes. And so Ms. Stone doesn't address how my constitutional claims can't act as a statutory claim in this instance, or why the Constitution shouldn't even be considered in addition to the statute in this instance. If this court is going to consider statutory claims, it should consider constitutional claims, because under the supremacy theory of law, the Constitution comes above the statute. So if I should be able to raise a statutory claim, I should be able to raise a constitutional claim today, and that's what I'm doing. I'm raising a constitutional claim under the First Amendment of the United States Constitution. I'm raising a constitutional claim under the 14th Amendment of the United States Constitution. And I'm raising a constitutional claim under Article 1, Section 10 of the Washington State Constitution.
Mr. Thomas, some of the materials that you submitted included a declaration from Mr. Green. Mr. Green talks about the connection of Mr. Ritzman to Liberty's Champion in a way that's now fairly important. Can you confirm that Mr. Ritzman is intending to film for this in this matter going forward, that he does so at Liberty's Champion direction and on their behalf each time?
That's not the point.
I haven't talked with my client about that specifically, but I can get back to the court about that. I don't feel comfortable asking or answering that question without talking to my client first.
The reason I ask the question is I'm trying to see if we can resolve at least some of these issues in a practical way here today, as opposed to prolonging issues. Would you like a few moments?
Yes, please.
You need a few moments.
Thank you, Your Honor, for giving me that time. Mr. Green said that he'd be willing to go along with that. In fact, as is argued in the motion and in the memorandum, Mr. Green put in the request for Mr. Ritzman each time, submitted the request on behalf of Mr. Ritzman to the Thurston County Superior Court, and it's stated in the declaration and in the memorandum. Mr. Green is the final authority about what goes on YouTube and what doesn't, and so Mr. Green has control over every step along the way, and so he'd be willing to go through with this court's suggestion or procedure.
Okay, all right, so thank you for that. So as I said at the outset, the issue before the court was not, and never had been, Mr. Green's role in Liberty's Champion, nor Liberty's Champion's role as in the social media, and the social media's ability to request and receive permission under appropriate circumstances to film and record under General Rule 16. Once again, concern is about Mr. Ritzman. Now, I have received materials here, including statements made by Mr. Green, that affirm Mr. Ritzman's closer connection to Liberty's Champion than the answers initially given to the court. Now, I know there is one particular filing for Mr. Green that the court received in advance of one of the hearings, and the court was somewhat surprised, actually. Some of the responses from Mr. Ritzman didn't more concretely nurse itself to those to Liberty's Champion. Having read what I've read here, and with the confirmation from you as Mr. Green's attorney, that Mr. Ritzman, each time he requests permission to film in this case, is filming on behalf of Liberty's Champion, the court's going to deem that to be sufficient for the media credentials requirement this court has made. Now, with respect to the specifics of the motion here today, the motion, I want to be very precise about this. The motion was to intervene in this case. Mr. Thomas, you are correct with respect to the state's in bringing this argument to this court. The court didn't have advantage of that either. At this point, I'm going to make my decision not based on anything that the state said with respect to the entitlement of intervention. But I am not persuaded that intervention is the appropriate mechanism for Liberty's Champion and Mr. Green in a criminal case. And so with that, I'm going to deny the motion. But I do believe that based upon the ruling this court's made here today, we've put to bed to the extent it was raised earlier by orders involving Mr. Ritzman, that is going to be permitted going forward absent, well, I should say this, trial judge or judge for any hearing is entitled in General Rule 16 to provide whatever limitations they have consistent with that rule. But in terms of the media credentials of Mr. Ritzman, of course, it's going to deem that to be satisfied.
Okay, thank you, Your Honor.
All right, thank you very much.
Thank you, Your Honor. Your Honor, as one aside, and we can do it on a separate day, but I don't know if Mr. Dang would like to do it now. We have filed an amended information in this case. This counsel is present. I don't know if he wants to do that now or wants to come in on a separate court hearing. The state can do it either way. So I would defer to Mr. Dang is here as well as his counsel.
First amended information?
First amended information, which I previously served on defense counsel.
Mr. Gray, would you like to reign on the first amended?
Your Honor, I've discussed that with the prosecuting attorney. I've attempted to discuss that with my client this morning. I feel that probably under the circumstances, it's better to have the note arranged at that time. There may not be a waiving of the traditional orient. May have to be full to put this over so we can get it arranged.
With that request, then we want to reign today, Mr. Dan.
Thank you, Your Honor.
Thank you, Your Honor.
Your Honor, permission number 5, 6, and 18 on the docket, State v. Knowles. Mr. Graham is suggesting